They limited the hours of operation of the church. They limited attendance. Again, the fire code says that this church can have 300 people in it. It seats at least that, so it's a decent sized church. And yet the attendance maximum for the Sunday service was 60, which is a little mysterious. And also how many activities could take place per year. They limited it to 4 to 6 activities per year in the temporary occupancy permit. The complaint states that there's actually no other known occupancy permit in that zone for other properties that restricts use this way for any secular property. In fact, there's an event hall in the same area that had a similar situation. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Alexa Kawlewski, a recent graduate of Notre Dame Law School.
And thank you for joining us for another episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it if you like the podcast and subscribe to our channel on YouTube, Spotify, wherever you're listening from. You don't have to wait until you listen to the whole episode. You can stop and do that right now. So this week we'll be covering a couple of interesting cases, a lot of land use actually this week, which seems to have been a more common topic in the last couple of months. So we're going to start with a case that involves a Michigan township that refused to let a newly acquired church property operate as a church. Then we'll go to New Jersey for a Christian addiction recovery ministry, so a religious nonprofit fighting a series of administrative and zoning battles. And then we'll finish in New Mexico with a really interesting eminent domain dispute between the federal government and the Diocese of Las Cruces in New Mexico. So first one here is particularly fact heavy, so let's get into it. So this first one is in Windsor, Michigan, and this started a couple years ago. In early 2024, a married couple, Don and Kathy Hamilton, purchased this abandoned church building. So it had functioned as a Methodist church for several decades. Like a lot of mainline churches, it started to dwindle. Not a lot of people left participating. They had to close. They sold. And so this couple, Don and Kathy Hamilton, bought the church building with the mission of nurturing a community of Christians in Windsor, Michigan. They already had a kind of church community, but they didn't have a physical property. So they bought this in 2024. We're going to have to go back and forth on the timeline a little because there are a lot of pertinent facts here. But the couple basically completed some non-structural renovations, made it suitable, and then began hosting the kind of things you'd expect from a church: weddings, Bible studies, worship and prayer sessions, and so on. There was a lot of administrative back and forth, but eventually the Township of Windsor sends a cease and desist letter alleging that the church was operating an illegal event venue in a residential area. So really interesting that the turn in this letter is that they're in fact not operating a church, they're operating an event venue, which is subject to obviously, occupancy requirements, licensing, things distinct from what would be required of a church. The township started issuing fines for weddings that were being held at the church as, again, unlicensed or unlawful events at an event venue. Actually, 2 of those 3 weddings were for the couple who bought the church's own family and friends. So as this escalated, there's a lot of back and forth that we're going to get into here. So I don't want to jump too far ahead. But basically, it all culminated in a lawsuit that was just filed. First Liberty is representing the church, seeking protection under the First Amendment, 14th Amendment, and RLUIPA, the Religious Land Use federal statute. So a few things I want to note as we go through this fascinating tale. It's, I think, first interesting to note that the township supervisor and zoning administrator, who was apparently pretty active in the denial of some of this permitting, was very vocal at the hearing that led to the difficulties escalating. This supervisor, zoning administrator, lives on the same block as the church. In fact, she is like a couple doors down. And First Liberty's complaint goes so far as to speculate that she's hostile to the existence of this church and its activities next to her property. Of course, it's a qualified statement in a complaint, but the fact that First Liberty raises this means there is probably some evidence to that effect. We will see. But one thing that I think is interesting legally, this property, they didn't buy a house and try to turn it into a church without a special use permit. This property had been used for decades as a church. It's a church building. And everybody knew this. The deed to the property is actually restricted, requiring the property to be used as either a church or a residence. So when the Hamiltons bought this property, they were told by the then supervisor, different supervisor of the township, that the property actually had to be used by a bona fide church. They were never told about any intended restrictions, limitations on religious activity, or attendance limits or anything like that, because those kinds of restrictions would be odd and inappropriate for a church to say, you can only operate during certain hours, or you can only have, 1/5 of the church's capacity present at a worship service. So not something you would expect to be a restriction when you buy a church to use as a church. Anyway, that being said, once the church started operating, again, the cease and desist letter came pretty early on. They were told they were being treated as an event venue, not a church, due to the various activities they were hosting, although they were like open houses and weddings and, come and see events and prayer events, more like the things a church would host than a secular event venue. So it's kind of odd that that's the turn that the township took. So as I started to say, the Methodist Church had been operating as a church for a while, same property, not unexpected that the successor owner would use it as a church. And it's interesting to note that in the municipal ordinances, while the church, the area in which this building is located is zoned residential, and generally a special use permit is required for a church in that zone, pre-existing uses are grandfathered in. And the Methodist Church had been using this as a church well before the current zoning ordinance existed. So I think the church should clearly be allowed to continue to operate without the permit. I think under their own ordinance, it should be grandfathered in. But the township had just continued to maintain throughout this fight that the special use permit is required, notwithstanding the pre-existing use, which they don't seem to acknowledge, at least as far as I could see in the legal proceedings. So I hinted at this a minute ago, but Mrs. Shaw, I think it's Bethany Shaw, so she's the supervisor and zoning administrator who lives down the street, appears to have been a pretty vocal opponent of the special use permit at the hearing. The record, at least the complaint, alleges that there was widespread support by the community. There was eventually a lot of frustration from members of the community that the church was being given such a hard time. But then this woman, Mrs. Shaw, spoke up. And I think it's also alleged in the complaint that she was instrumental in the background in making sure that the difficulties increased and that the occupancy permit was delayed, and that the special use permit was tabled and all of this. It seems to me like a clear conflict of interest. First Liberty also mentions this in its complaint, since she lives on the same block and has an interest in what happens on that block. But that apparently was not raised until this complaint was filed. So the legal background gets a little bit messy. The church, cooperated, even though they didn't think they needed the special use permit. They submitted the application for it anyway, even though they thought that they should be a legal non-conforming use, grandfathered in. After these hearings went sideways, they actually withdrew the application and just decided, well, we can operate as a non-conforming but legal use because this was pre-existing use as a church. As things started to escalate, one other interesting fact as these things escalated is the authority who's supposed to issue occupancy licenses separate from the special use permit kept refusing to do so, ignoring emails and so on, and they just couldn't get it. So they didn't have the special use permit. They didn't even have an occupancy permit. Then there was some political action. I think the Hamiltons talked to their local state legislator, and then suddenly a temporary occupancy permit was issued. But it led to the current lawsuit because there were like some crazy restrictions. They limited the hours of operation of the church. They limited attendance. Again, the fire code says that this church can have 300 people in it. It seats at least that. So it's a decent sized church. And yet the attendance maximum for the Sunday service was 60, which is a little mysterious. And also how many activities could take place per year. They limited it to 4 to 6 activities per year in the temporary occupancy permit. The complaint states that there's actually no other known occupancy permit in that zone for other properties that restricts use this way for any secular property. In fact, there's an event hall in the same area that had a similar situation where prior owner owned an event venue business, closed the business, a new event hall company purchased the property, and they got grandfathered in and have not been subject to attendance limits or any of the stuff that the church is having imposed upon it. There's some other stuff in the complaint saying that other churches have similarly not had such problems or restrictions placed on them. So this looks kind of targeted. Again, it's early to tell. All I have to go off is the complaint, which is necessarily going to be one-sided because it's only filed by one side. But I think the methodology that the township defended is interesting and in my opinion, clearly unfair. In relying on the 60-person capacity, the township said, well, in the last years before that Methodist church closed, that's what they had there every Sunday. They'd have 50 or 60 people. This is, what was going on the property. But again, that's based on the dwindling numbers of a dying church in its prior years. If you looked back a couple of decades when the church was thriving, I'm sure you would see many more than 60 people attending a Sunday service. So spurious reasoning, in my opinion. Anyway, the complaint is alleging what you would expect: First Amendment violations, both free exercise and establishment clause, state law violations, as well as RLUIPA, the federal land use statute. I think they're strong claims, especially because it's not a neutral, generally applicable law. If you have exceptions or disparate treatment for secular organizations, we have a lot of Supreme Court precedent for that under the First Amendment. And then on RLUIPA, you can't, if you're treating secular special use cases or variances or carve-outs, any of them at all, more favorably than a religious one, then it's no longer neutral and you're treated more severely under RLUIPA. So I think the claims are pretty strong based on the disfavorable and apparently discriminatory treatment that this one church is facing in the community here. So I guess I'll wrap up here, but like a lot of zoning issues that happen on a very local level, it seems to me from the limited record we have more like a personal dislike for the church by maybe one particular person or a few, rather than an even-handed application of the law. So we'll be following this one closely. The land use, religious liberty cases are very important. Churches not being able to use their property without being harassed is a big problem. And I'll also just end with this and note that it's really important to see things like this where religious orgs take strong legal action quickly. It's important not to let a local municipality get away with this kind of anti-religious animus and mistreatment of a church. So to bring in First Liberty to aggressively, respond with federal litigation, that's the right call. It will hopefully make the municipality realize that it's in over its head. You often see things like that. One-sided litigation can end something very quickly, right? You'll see it on the other end where I've talked about this in the past, where you have these like after-school Satan clubs who come into a school district and they want to have an after-school club, and none of the parents really want it, but the ACLU or the separation, what do you call that? The what is it? The Association for Separation of Church and State or whatever it's called. They come in, they have a lot of lawyers, they're well-funded. District that's like, we don't want this legal fight. We can't afford the lawyers. We'll just back down and let it pass. So I'm kind of hopeful that the same thing will happen on the other side here. First Liberty is aggressive and well-funded and very good at litigating these kind of things. And so hopefully this little municipality will realize, rather than have a multi-million-dollar lawsuit, maybe we should just let this church be a church.
The one thing that I found interesting in the facts as you laid them out, Frank, is that the municipality seems to take the stance that this isn't a church at all. It's an event venue space or something comparable. And that's probably also part of their defense of their actions as well. Maybe we don't treat other churches like this, but we do treat other event venues like this, or we would, even though the facts, as you then later mentioned, seem to indicate they have not, in fact, treated other event venues this way. But it's sort of bizarre. It's a bizarre stance for the municipality to take, that even though all of these individuals call it a church, they hold worship prayer services, which is obviously very similar to like general church activities. They're not just only exclusively holding things like weddings or parties or something like that that would make it seem a little bit suspect for them to be a church. And yet the municipality is saying, we're calling you an event venue space, and then we're capping your occupancy and we're capping your use hours throughout the year or something like that. So it's a bit of an odd stance to take, but that might be the direction the municipality is going to try to defend the actions that they took.
Yeah, no, it's a great point. And I just looked up an image of the church while you were talking to see, like, this is not a house that was converted to a church. It's a church, like maybe not a particularly pretty one, but like the high steepled ceiling and the stained glass window in the front, and like it's a church. A church is a church, and that's a church. And it's not like it would be one thing if you bought what is clearly a church building and immediately like put a bar and restaurant tables in, but you like look in the middle of it and the inside, it's a church. It has
Right.
seating, it has a sanctuary, they're holding weddings and prayer services. Like there's just no good factual reason to say, well, this is no longer operating as a church.
Right. And it's actually quite similar to the second case that we're talking about today. We're moving from Michigan over to New Jersey and from a church to a religious nonprofit. So a different kind of organization, but a very similar zoning and administrative challenge. So in New Jersey, there is an organization called Adult and Teen Challenge of New England and New Jersey, which is a bit of a mouthful. So we'll call them ANTC. And they operate with the mission to help adults and teens recover from substance abuse addiction by finding faith in God. So that's the religious aspect of their mission. And the way in which they're putting that into practice is that they have a number of residential homes throughout the New England area for men and for women who are seeking recovery from addiction, where they offer things like counseling, vocational training, classroom studies, and life coaching. And one of these programs is a more long-term program, so anywhere between 10 months to 12 months, so a full year, where people stay at their 88-acre Stanton Mountain campus in New Jersey. And this site has been growing since 2015. So in order to continue operating and continue serving the people in the community, they wanted to improve it at the end of 2022. So we're going pretty far back again to some interesting facts. So when they first went to improve the site, they applied for the proper permits and certifications from the townships. This is the Township of Clinton, New Jersey, where they're located. And the township initiated an administrative zoning action against them, asserting that ANTC needed township approval to continue operations. So it wasn't simply that they needed approval for the specific permit or certification that they were seeking, but to continue operating as a whole, to run the home. So initially, ANTC is complying with these bizarre and kind of aggressive request from the township. They're allowing them to do inspections. One of the inspections was a fire inspector from the township, who then demanded that ANTC replace a battery-powered exit sign with a wired exit sign. Very specific replacement. You can envision the exit signs, and it's pretty small change. It's a bizarre change to ask, but pretty small change. And ANTC was happy to make the change and do the replacement to be sort of up to code. But they needed a permit issued by the township in order to make the change. But the township refuses to issue the permit. And they're refusing because of the ongoing zoning issues. So for the 7 years before applying for the permit, the township had not pursued any zoning enforcement against ANTC, but all of a sudden, when this permit request comes forward for this continuing construction and specifically for this exit sign, the township is asking for zoning changes. So you have two things going on at the same time. There's the zoning and then the permit. After the application, the township starts questioning ANTC about their Christian identity, their management philosophy, and their nonprofit mission. All things that are a bit bizarre to be asking the organization about when you're just reviewing a zoning application. You might be ensuring that they're in fact a nonprofit. You might be ensuring that they're in fact using the space for what they say they're using it for. And that would make sense in relation to the use of the property, but just asking in general about their Christian identity. And we don't know exactly what these questions or the questioning looks like, but sort of like general questioning of what their identity as an organization is hints at a greater animus against the organization or their mission in particular, rather than you're just seeking to find out information about the use of the property. So the township has been in administrative hearings with ANTC for the past 2 years. This has gone on for a pretty long time. And finally, on July 12th of 2024, the township alleged that ANTC changed the property's use without approval. So changed the zoning, essentially, without seeking the proper approval. They then imposed a $2,000 fine on the organization with an additional $1,000 fine per week that they continued to violate. And that really means that $1,000 additional per week for every week that you stay open. that you operate. So not only are they facing the monetary burden of consistent fines, but they also cannot operate their main house and have residents living on site until the construction can be completed. So First Liberty, again, along with two other law firms this time, sent a demand letter to the township alleging that those actions violate the First Amendment Free Exercise Clause, 14th Amendment Equal Protection and Due Process, the Fair Housing Act, and New Jersey state law. So I'll focus a little bit more on the legal aspects of this than the facts, but of course the facts are important to ascertaining whether or not there's an actual legal challenge here. So the demand letter goes through each of these legal issues, the first, of course, being the religious liberty concern. And on March 14th, 2025, the township refused to issue the necessary permit. So that's why the demand letter was sent now versus back then. They've been going back and forth in these administrative hearings, going back and forth trying to get the construction underway. Finally, the township refuses. They cite the ongoing zoning proceeding as the reason that they will not issue them the permit. And they direct the ANTC to include the request in a pending application. So they're basically just pushing the can down the road, telling them to do more and more administrative tasks. So ANTC now cannot house residents in their building. And this is what First Liberty and those other law firms are alleging imposes a significant burden upon their religious programming. It imposes a significant burden upon their operations in general because they actually cannot operate this specific house. But it specifically violates the free exercise because the zoning hearing record reflects a hostility to religion and their religious identity, potentially a pretext for just not wanting to have them in the area or in this specific spot, questioning their Christian identity, their parachurch status, their vocational ministry, their nonprofit character, and their accreditation. So again, you're seeing just a lot of things coming up in the zoning hearing that would be a bit bizarre for the board to really be digging into if you're just trying to ascertain whether or not they're using the property in the way that the zoning law permits. So rather than acting as an unbiased quasi-judicial body, this is what the demand letter says, the board has shown a barely veiled and unfair hostility towards ANTC's mission. So that's one aspect of it. They're also alleging an equal protection and due process violation because it's a refusal to permit merely to correct a safety concern. And given ANTC's religious identity, its residents' protected status, because remember, they're working with residents who are suffering from addiction, and the township's prior history with the property, which was basically no history of challenging the zoning issues, and the existence of comparable rehabilitation or residential recovery facilities treated more favorably, then you can allege both the equal protection and the due process challenge. They're also alleging a RLUIPA violation because they're a faith-based ministry and the refusal to issue the fire safety permit displaced residents and disrupted the recovery program. So the township cannot claim that they're blocking a permit for a required fire exit sign as the least restrictive means of achieving zoning compliance. At least that's what the demand letter is saying. Is it'd be a bizarre way for the township to argue is that this is just the easiest possible route that they could be taking to achieve compliance in the zoning rule. This also is a Fair Housing Act violation, according to the demand letter, because the FHA, the Fair Housing Act, prohibits making housing unavailable or denying a dwelling because of disability and requires reasonable accommodations in rules, policies, and practices to afford persons with disabilities an equal opportunity to use and enjoy a dwelling. It goes on to also allege violations of New Jersey law and Clinton Township Code. So really digging far here into the weeds. But this letter was filed on June 9th of 2026, so just a couple weeks ago, and the town has 14 days to respond. So that would be about the end of this week, beginning of next week was when they would expect a response from the township. This is quite similar to what we were just talking about over in Michigan. Quite common to see zoning and RLUIPA challenges often brought on by local county boards facing religious nonprofits or churches, maybe more specifically. It's important to note that administrative red tape, especially when it results in monetary penalties or an inability to actually serve the community in any meaningful way, can be a larger hurdle to a lot of these organizations than even litigation would be, um, especially when it ceases their operations entirely. This is also something that many of our listeners might know, but it's a trend you see coming up again and again in these cases where it looks like it's a NIMBY, a not in my backyard sort of defense from the township or from maybe individual people who are on the board or in the community who are raising really strong opposition to the operation of a particular church or a particular religious organization in an area simply because they would just prefer for them not to be there, or they would prefer for them not to be located so close to their own property. And so they're raising a lot of administrative struggle for these groups when there's no legal reason to be doing so. And of course, these groups have a right, so long as they're properly permitted and properly zoned, to be using that space for those things. Also, the facts of this case seem to indicate that ANTC was fully willing, and is still fully willing, to comply with all necessary steps, like to receive the proper permitting, to actually change the sign and update their construction. And it's not a violation of the use requirements of their land. They actually made no zoning change because they have still been using the land the way they used it for all of the years prior when there was no concern. So you could have a different case where the construction change was the crux of the issue, and that issue might be more challenging if the nonprofit or the church actually changed parts of their use, the building or the use of their space, maybe added to it without getting proper permitting, or if they're a church and they all of a sudden stop operating worship services and they just start doing parties or restaurants or something like that. You would have certainly a different case there, but it's simply not what you have here. I mean, ANTC is willing to make all of the necessary changes under the permits and hasn't changed what they're doing with the property. So hopefully the township, like we mentioned with the situation in Michigan, will just read the demand letter and recognize that there isn't really much of a legal foot for them to stand on here, and just grant the permitting and withdraw the zoning violations. But we shall see, and we'll follow the story in the coming week.
Yeah, just 2 points I want to make real quick. I think it's really important to point out that there are two common objections in cases like this. You've hinted at both of them. One is just a secular dogma that does not want religious organizations or people involved in civil society. And the other is the NIMBYism, which can be separate from religion, and probably is in a case like this. So on the first one, I think it's just awful because, here you're talking about some of them, like we have a drug crisis in our country and in our culture. And so these kind of faith-based rehabilitation programs are a really important opportunity to help people recover from drug addiction. And so to wage a war because it's a religious organization, and stop an organization over what seem to be trifles from doing this needed work is just frankly shameful, and a real problem for society, right? Like you see the same thing in like the foster care situation where they're trying to force Catholic organizations out because they won't adopt kids out or foster kids out to same-sex couples or whatever. We need these organizations. They're doing needed work for the most vulnerable people in our society, and to try to push them out because they're religious, again, is just shameful. And then on the NIMBY side, I can understand this as a property owner, right? Like if you own a house or a vacation home or whatever, and it's in a nice rural area or whatever. I haven't looked at the landscape of where this retreat center is located, but I assume that they probably have fairly well-to-do neighbors who don't want recovering drug addicts sharing their neighborhood. But they have to be somewhere, right? Like this is needed work. These are members of our society, and like you can't. Where are you going to put these things? It's got to be in someone's backyard. And again, it's not like you're, encouraging deviant behavior. You're not putting like an open air drug market or an injection site or whatever next to somebody's house. There's a place for people to recover. So I get it. Like maybe not the neighbors you want, but this is part of what's needed for the common good. They have to go somewhere. And the NIMBY problem is just always a problem because people in theory want recovery houses for addicts and shelters for homeless people, but nobody wants them near them. But it's just the reality that they need a place, and this is the place that the organization in fact owns. Well, with that, we will go to our last case, also a property dispute, but a little bit different. This is not in the realm of religious land use so much as eminent domain. This one's fascinating. So, what happened here? This is on the U.S. border in the Diocese of Las Cruces, New Mexico. The federal government filed an eminent domain action seeking to take title to about 14 acres of land that's currently owned by the Catholic diocese down there by the border, and they want to use the land to build part of the border wall. So the diocese tried to block it. They're fighting the eminent domain action in court. The diocese claimed that it would substantially burden the faithful who travel to this shrine near the border if this land were taken. So the site of this proposed property taking, it's at the foot of Mount Cristo Rey, which is you'd probably know it if you saw it. There's this huge crucifix and shrine dedicated to our Lord. It's like 29 feet high on the top of the mountain. Right now, this is allowed to go forward. The district judge said the federal government could proceed with depositing the money that they're going to give to the diocese if the eminent domain action goes through. The challenge is still ongoing on the eminent domain case. But so I want to qualify like everything I say here because it's a new case. The details and facts are kind of fuzzy at this point. From the record that I've been able to see, like the federal filing is just a couple pages saying that they have jurisdiction to file the eminent domain action. There are a couple of articles. I read one at EWTN. I read one at the New York Times that's kind of comical in its title, that it was like basically Trump's border wall versus Jesus, which I think it's a little bit, maybe a lot more nuanced than that. But point being, the details are pretty fuzzy. So I'm going to qualify everything I say here that depending on how particular facts come out about where the property is actually being taken from, what the actual objections are, this could go either way. So I'll just say a few things. On the one hand, of course, I'm deeply troubled, and Napa Legal is deeply troubled by government infringement on religious exercise. So if there's an eminent domain taking that includes the actual land that a church, a shrine, a religious monument is using for free exercise, that's a huge problem, right? Both morally and constitutionally, that seems like it's ripe for religious freedom violation litigation. But on the other hand, at least from what I can see in the initial filings and the early articles on this, the taking doesn't seem to actually seize any land used for religious exercise or worship. I haven't seen a map with like a cutout of what land they're proposing to take, but the articles say it's at the bottom of the mountain. The statue of our Lord is at the top of the mountain. So it's unclear what's really going on here. Spokesman for the federal government has said that the path, the walkway that goes up the mountain that pilgrims take to the statue is in no way impeded by this taking. It doesn't actually affect the land that is used for pilgrimage or for religious worship. Again, we'll see as facts come out in this case whether that's the case. But for me, the question is, right, whether religious exercise is actually being infringed upon. That is the question we should be asking. And again, from some of the initial statements I'm seeing from the diocese, from those interested in the case, I can't really tell whether that's the case. One quote that I thought was interesting, there's a group called the Mount Cristo Rey Restoration Committee, which is an independent group that tries to keep this site clean and accessible, said this border wall will, quote, look like a scar on Mother Earth. So that looks less like an actual religious exercise concern, so much as a concern with what the property is going to be used for. The diocese said in a statement last week that the wall is a physical manifestation of this government's attitude toward immigrants. Nothing could be less Catholic. So again, I'm not sure from the statements whether the argument is actually that this impedes the act of religious exercise or worship, or whether there is a policy disagreement between the diocese and what the federal government wants to use the property for. Now, the latter might be a legitimate argument, but it certainly changes the nature of the claim if you're arguing a free exercise problem. Because again, from what the administration has said so far, it looks like the wall being built at the bottom of that mountain will not interfere at all with the pilgrimage path up to the shrine. So there's a real outstanding question to me of what the actual motives are, what the actual outcome will be here. Would this taking and this border wall actually interfere with religious exercise? Will the wall impede worshipers, or will the wall just be like an aesthetic monstrosity that interferes with the beauty of the holy site? If any of those things are true, then we do have a religious exercise problem. But again, if the fight is more about principled opposition to this administration's building of a border wall, different question. So I don't have much more to say. This is very new. Details are sparse. It's early on. And it isn't clear to me from the pictures, the maps, and so on, whether this eminent domain taking in this wall will actually interfere with religious exercise or not. Don't know yet. And to me, that's what the case hinges on. Time will tell.
We've seen a couple of these in the past couple of years too, where you have eminent domain cases, the federal government coming in and wanting to use the land. Typically, you see it being done for construction, sometimes like natural resource management or flood management, things like that. Usually because they're more rural areas, not as much seen in urban areas. And then you have a religious group of some kind who is claiming that this particular plot of land that the government wants to make some kind of adjustment to or take for some kind of use is the actual plot of land that they use to perform a worship service or as a pilgrimage site or something like that, which to your point, again, Frank, is just the question really is what that hinges on here is the actual piece of land that the government wants to take, the very piece of land that the diocese is using for this shrine. And that seems to be a bit up in the air, potentially not if it's land at the bottom of the mountain and there's no barrier between pilgrims getting from the bottom to the top. But still an interesting case to follow to see what more comes out about it too.
Yeah, that's a good distinction that you made a minute ago that we saw the Supreme Court refuse to act on the Apache stronghold case down in the Southwest where they transferred rights over to a mining company. But it's a fundamentally different question there because they were going to turn the entire worship site into a crater. This is different because it is unclear whether the land that's being taken actually, it certainly doesn't take the fundamental worship area. It's unclear whether it takes any part of the area that's actually used for religious worship. So fundamentally distinct from a case like Apache Stronghold. All right. Well, with that, I think we will wrap this one up. And thank you for joining us for another episode of the Napa Legal Weekly Podcast. If you want to know what we're up to, you can visit our website at napalegalinstitute.org, where you can see upcoming events, new resources. You can donate to our organization so we can keep doing what we're doing, and that would be greatly appreciated. In particular, look out for our Napa Legal Nonprofit Summit, which is an in-person event on legal fundraising and other types of education and formation for nonprofit leaders and the professionals that serve them. That's going on a month from the day of recording. So that'll be July 22nd in Napa, California. If you want more details, you can go to the website or you can email us here at Napa Legal. And with that, we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious freedom and the work of faith-based nonprofit organizations. So we'll talk to you next week. Thanks for joining us, and God bless you all.